Good afternoon, ladies and gentlemen. Today is episode 5, where we have open sesame on questions. And today I speak to the LLB class of 2022, where they can actually ask anything and everything about the law. So I'm currently joined with Miss Ndondela, and she has a couple of questions for me. So I will try and shoot from the hip, and you can ask. Welcome to the show, Miss Ndondela.
Thank you. My question is with regard to civil law, specifically interstate succession. Whenever a person dies interstate, their estate is above the threshold that the court is allowed to assist in dissolving the estate, and a lawyer has to be hired. So I know that in terms of dissolving the estate, there has to be an application for executorship. But if there's a minor involved, there has to be a bond of security before getting the executorship. So my question is, if throughout that whole process, the estate, for example, there's a house and it requires regular maintenance and all those things, but the dependents are unable to pay for it out of their pockets. So I'm wondering if they are able to rent out the house before even the whole house is transferred into the dependent's name.
Or maybe the new owner. Now,
Yes.
obviously, when you come to estates and specifically interstate succession, obviously there is rules and regulations that regulates the whole process. And if you look at it first, you look at the Administration of Estates Act. It will guide you. It says to you what's the duties of an executor. So whenever a person dies, there must be an executor appointed. And obviously, if the siblings is minors, then obviously they need a curator, a guardian to actually guard their interests. So we'll first approach the High Court to say, okay, this is minors, let's appoint a curator for them. After that, you will now open what they call an estate bank account. An estate bank account is where every money that is due to the estate will go into. So if, for instance, they cannot pay and they decide, okay, let's rent out the house and we'll stay with family members, then obviously all the income that they generate from that will be paid into the estate bank account. And then the executor now, there's now a difference between the curator and the executor, but it might also be that it be the same person. But for safety's sake and for conflict of interest, I would prefer two different people. Then the executor will then have to now take that money from the estate bank account and maintain the property so that it's in a livable condition until maybe the minor kids is majors and they start working where they can actually now pay, because obviously there's also now a conveyancing aspect that comes in. If I transfer property from me to you, there's conveyancing attorneys that needs to come in because they need to transfer the deed of ownership needs to move from me to you, and there's fees that you have to pay, and it works on a sliding scale. So that is what more or less has to happen. But always an estate, you report it within 14 days. The master needs to know about the death, and you have like approximately 8 months to sort it out. But minors, also what they call the guardian fund. If there's funds that's due to the minors, they will be paid into the guardian fund, and then on a monthly basis, they will get some sort of an income that comes out of that fund so that they can be looked after if they are minors until they are majors or until the money is depleted, depending on how huge that sum of money amount of money is. But normally, if you get with these municipality houses, the value to the house is not that big, and there's maybe like outstanding rates and taxes. Then the proceeds of that sale or the proceeds of the house, so it's better sometimes for the kids to just keep the house, at least when they are majors, they can have something to fall back on. And but then they need to make sure if they rent it out that the people staying in the premises are paying the rates and taxes, or the executor recoups the rates and tax money from the people renting the property so that the property can be maintained. That's my other things. But there is a lot more to this than what meets the eye, but that's basically in a nutshell if you want to look at it. But there's a lot of other aspects that you can now zoom into and sketch scenarios for that. But that's more or less when it comes to interstate succession. But just remember, there is also a lot of forms that needs to be filled in, how you go about nominating the person to be an executor, and also what information you need to declare to the master so that the master can decide, is this an estate where you need to appoint an attorney to help you with the winding up or not. And that threshold currently is 250,000. So if the estate value is below 250, you don't need an attorney because you don't need to do what they call an L&D account, liquidation and distribution. If it's above that, that's when you start needing it, because you have to draft that account and there is certain legal requirements that you need to meet.
Okay, follow-up question. You mentioned 14 days. So I'm wondering if all the other processes have a specified amount of time, like you mentioned, the other 8 months. So if it happens that dependents have complied with all those regulations and requirements, and we've recently been in a pandemic, and we're still experiencing a effects of it. So that means, in my understanding, that some processes may be slower than
Mhm.
the other, and a lot of people did unfortunately die during this pandemic. So there's an overflow of
Yeah.
work that the courts have to go through. So if it happens that all those the dependents have complied with everything, but the time is dragging on longer than it should. In that time, are the dependents able to make decisions for the purposes of being able to survive in that moment?
Yeah, they can make decisions, but it means that they need to have consensus. But obviously, if it's minor children, then obviously that curator or whoever is taking care of them at that point in time can make the decision, but in consultation with the master, waiting the outcome of the processes. So that is one of the ongoing things. And obviously, with the COVID pandemic, there is certain provisions that made that we know that certain processes, because people are working on skeleton stuff, so they do make that provision so that you don't need to be here in 14 days. They would condone if you come and do the reporting a little bit later, maybe a month later or something, because you first need to deal with the burial, and maybe it's at home. You have to first go there. It's 2 weeks already gone. Stay another week there, then it's another week. It's already 3 weeks after the death already. 14 days has passed, long time. So they do take cognizance of these challenges that people also have. So it's not like cast in stone and that you should be there, but they would want you to do that. That's what the law says, but they would condone maybe that late filing, but obviously within limits.
Thank you for answering my question.
Pleasure. And back over to Mr. Bongani Pahlela.
Hi everyone, my name is Bongani Pahlela. Thank you, Mr. Hart, for giving me a chance to actually ask you this question. My biggest concern is with regards to social security law. There was an issue regarding the COIDA, which is the Compensation for Occupational Injuries
And Diseases
and
Act.
Diseases Act. Yes, you know about it, obviously. It's Actually, they say you can actually claim using the act whenever you whenever you incur
An injury on
an
duty.
injury or a disease
On duty.
on duty within the scope of employment. So there was a case, which is the case of um, MEC for the Department of Health versus Dinego.
Mm.
The case is about a doctor. The doctor actually was raped while she was carrying her employment duties. So the matter went to court, in which she was trying to claim using the quota, which is actually reasonable because you are entitled to a claim whenever you.
Mhm.
It's an injury, it's a damage. So
Mhm.
yes. So the court actually ruled that she cannot claim using the quota, which to me is actually putting me in the dark. Like I'm actually confused. How is it that everyone that actually incurs damages, um, which could be an injury or it could be a disease
Mhm.
in the working field, they're able to claim. But when it comes to a person who's being raped, they cannot claim inside, like using the quota, which is actually the court based the reason on rape being something which you can get wherever you are. You can be raped while you're in your home. You can be raped in any area. But how in an area whereby you were carrying your employment duties, which just made you vulnerable into such an event, which
Mhm.
is so unfortunate. So to me, is I need a clear overview on how is it that the COIDA is kind of being exclusive of certain people who incur specific injuries.
Okay. Now, first, one needs to check this person that got raped, were they an employee at the time that this incident happened? So you check first that, is this person an employee as per the Labor Relations Act? You check, does this person meet the requirement of being an employee? Because
Yes.
you get a lot
Yes.
of doctors, they have their own private practices, but they also work in the hospital as freelance contractors. So obviously, we don't know what's the actual facts of that case because there was must now evidence that was led. So one needs to unpack that first to check background facts. Was she an employee? Okay, if we say she was an employee, which means that her primary source of income is derived from her job as a doctor within the public sector. She's now an employee. Then one checks now the second one. Did this happen during her working hours? Was she at work when this incident happened? That's when we talk about cause and scope of employment. At work and performing her duties? Or was she commissioned to go off site and go do certain work off site, which is still linked to her employment? So that is the two things. Because if we can get those two things, we fall within COIDA. And then we need to know also that if you use COIDA, your damages would be limited because you can only claim for certain damages under COIDA. You will never be placed in the or the position that you ought to have been like or out of pocket expenses. You won't get everything. So if one checks the set of facts and one looks through the evidence, it will make it clear to first establish was this person an employee and were they within the cause and scope of their employment with the employer. So that's our starting point. How do we need to unpack this judgment? Then we go look at what they call the ratio dacidendi or the reasons for the judgment. Then you'll see now who's probably in that judgment. I haven't read the judgment, but I will make it my duty now to go and read it specifically to see what was the reasoning. Maybe they said that she does not fall within the category of employee or that the injury, and injury is now defined as broad. It can include even a disease. Say, for instance, like we come out of COVID, and if you contracted COVID while performing your duties as an employee, you can also claim for their damages. So they allowed people to do so. So one needs to check now that once we've established employee, then we go to cause and scope of the employment. And once we have that, then we can say, okay, she's covered by COIDA, or she has another sort of claim for delictual damages against whoever it is. If you know the perpetrator, or if you go after the MEC, but not under COIDA. Because remember, if you go for MEC, then it means like you're not using COIDA, but you're using most probably the government department like health. You're suing the Minister of Health to say that you've incurred damages because there was an unsafe work environment or whatever the case may be. COIDA is now, you have a limited claim in terms of that specific act, and that you do, that process you follow at the Department of Labor. And it's the duty of the employer to actually launch that claim on behalf of the employee. So one needs to first check, was it an employee? Is there employment relationship, and did it happen within the cause and scope of the employment? Then you know you're in a safe space that you can say, I can, but there is exceptions on COIDA. Now you need to check, was she maybe not like sort of half doing a certain portion of her work as a doctor and still running a private practice, which is her primary source of income. So all that surrounding facts, one needs to check them and work from there.
Okay. One last question. My question is, don't you think the implementation of the COIDA actually defeats the obligations of the Constitution, which is fairness? So basically, all I'm saying is there fairness within the working atmosphere? Let's say, for instance, if COIDA actually specifically excludes certain people who are within the employment industry, let's say it exclude, let me say, members of the police, um, South African Police Service.
It's all the people that's rendering sort of half essential services that
Yes,
has a risk element to it. They are excluded because in that line of duty, like for instance, a Metro Police officer, you
yes,
know already when you leave your house, I'm going to patrol the streets of Johannesburg, for instance. There's a risk that I might be shot at. That it emanates from the job, and I reconcile myself by taking this job that this is a possibility that it can happen. So there is certain classes, and I understand because yes, you get injured. Yes, there's other ways of actually claiming for damages. So
Yes.
COIDA does make that. So obviously, you just need to check now. If I'm not covered under COIDA, there is still other common law remedies available to you. So the fairness is there. You just need to choose the right remedy. Because obviously you need to get compensated for your damages. So you need to check, is COIDA the route for me to follow, or can I use the common law? So you need to, whoever's your lawyer that's assisting you, need to also guide you on those processes to say, listen, yeah, I think COIDA will not help us in getting the maximum benefit that you are entitled to. Let's rather use the common law.
Yes. Thank you very much, Mr. Hart.
Pleasure.
Thank you. Who's next?
Good afternoon, Miss Matebula.
Hi,
It's a
Mr.
pleasure
Hart.
to host you, and I believe you got a question. You can give that question to me, and we'll try and answer it as best as we can.
Okay, so I wanted to ask about the reputation of the legal profession in itself, because there's always this misconception that if you're a social butterfly and you happen to end up on one of these Instagram pages, or you end up with a specific following on social media, that your reputation in the legal profession is at jeopardy. So I just wanted to understand exactly what's like the implications of that particular topic.
Now, obviously, you need to, and this is the unfair part of our profession, that whatever we do in our social lives normally affect our professional lives. And hence, I always say to the guys that whatever you do, be responsible in how you do it, because people are people, and if they get something to badmouth you or to use against you or to make you look bad for them to grow in populism, they will use it. That's the unfortunate part of our industry. So, if you know you're a social butterfly, please make sure that you always surround yourself with people that you know you can trust. They won't post unnecessary things. And that is the limitation that we as legal professionals have in our lives. Because obviously, I mean, if I'm constantly drunk at a tavern on weekends, I hang around the tavern because that's what I do. But it doesn't take away the type of lawyer I am. But people will perceive you as a drunkard lawyer. And they will not come to you to say, listen, yeah, I don't trust that lawyer because every weekend he's drunk. Who said not he's going to come drunk to my case, or on a Monday he might not even attend when our matter is on the roll. And that's the perception. But it doesn't, being a person that maybe consumes alcohol or goes to parties doesn't say you will be a bad lawyer. But there's that perception that people have of people behaving in a certain way to say, I won't trust that person. And that is now the thing. And that limits sometimes us as professionals not to say fully express ourselves when we are with our friends and family, because there's always a camera lurking or somebody that might just come up and say, oh, did you see Ms. Matebula? She was at a party last week. No wonder she's not even listening to the questions in court, or she can't do something proper. And that is our little sort of half catch 22 situation that we find ourselves in as lawyers. And unfortunately, so we need to behave in a certain way in the public eye so that we are not to perceive or not perceived as to be unethical and lawyers that's involved in illicit activities. Also, it's similar, like say for instance, if you have a lot of criminal cases, obviously you'll have to consult with your clients, and 10 to 1, some of them committed crimes. Now suddenly you are being labeled as a corrupt lawyer or a lawyer that takes on choncho and all these types of things. So you need to really be careful in selecting how you conduct yourself on a daily basis in the public eye. And that puts a damper on you as a person. So by virtue of choosing this career, I always say to guys, if you don't have a passion for being a lawyer, don't become a lawyer. And also know that from the get go, every move, every step, you need to be calculated in what you do. And obviously, even we as human beings, say for instance, you drive on a road and a taxi cuts in front of you, you get angry. And you might get angry to such an extent that you start swearing at it. Then, just unfortunately, there's somebody with a camera taking a photo, a video, and saying, look at this swearing lawyer. Then it creates that bad impression about you. And That's the unfortunate part about it. And there's no remedy for us as lawyers to that. We just need to take cognizance of our surroundings, the people that we surround ourselves with. And obviously, we know that we have now what they call the POPIA or POPI Act that says people need your consent, but in South Africa, people will post and later on say sorry. And if you want to sue them, you can't sue a man of straw because it doesn't help you sue a person that doesn't have money because you'll throw good money after bad money. So that is now the thing that I would send out to the youngsters out there, upcoming lawyers. Watch your steps. Don't do things that would be perceived in the public's eye as being irresponsible, unethical, or immoral, because it might just be used against you at a later stage. And you might think, I'm not fazed about it, but later on you do a very important case and then you just see here's a video popping up. Poop. Here's Miss Matebula dancing on a table in a tavern. And that was just you enjoying yourself as a human being. But it doesn't say that you are a bad lawyer, but these things happen. So that is now the message that I can share with the youngsters to say, listen, yeah, always be cautious of your surroundings, take cognizance of where you hang out. And I know now people will think you may be better than them or you are different from them, but sometimes you outgrow certain people, you outgrow certain phases, you outgrow certain things. So you need to be sure, do I want to be associated with this? Because it can affect my professional career. People watch LinkedIn, they watch TikTok, they watch Twitter. Everything and anything you do, these people that employ, they do watch these things. And once they come up, somebody say, it's going to spoil our company's reputation, throw that CV in the bin. And that actions of yours there on a party doesn't say the type of lawyer you are. It doesn't, but that's the unfortunate part of it. It happens every day that people get scrutinized for things they do in their personal life and it gets attached to their professional life. And I mean, I had a journalist now, she posted something about, as a resident of Joburg, I'm really dissatisfied with the type of service we're getting from the municipality. And they said she's a journalist, she should not hold political views. But she said, I'm not posting as a journalist, I'm posting as a resident of Joburg, but they still make that connection. So that's the same with us as lawyers. We talk as individuals, but it will always be connected to our profession. And that's the danger of our work and how we need to conduct ourselves. So we need to be cautious about what and how we do it.
Thank you, Mr. Hart.
Pleasure, Mr. Matebula. Good afternoon. And today, after a lovely conversation with Ms. Matebula, we are joined by Ms. Winnie George, and she has questions. And Ms. Winnie George.
Thank you for having me, sir. I wanted to ask your opinion on the recent Constitutional Court judgment, that is the Rafaneka case, that questioned the constitutionality of the LPA Act, insofar as it disallows foreigners from being admitted as attorneys of the High Court unless they have a permanent residence. I wanted to ask about your opinion, whether you think it's fair, and what options are available to students.
Obviously, first and foremost, and I understand where the grievance for all foreign national students come from, because you come here in anticipation to study law and you study the South African law, so you get schooled and educated on how to apply and practice South African law. So for me, that judgment, I think it was a little bit too quick for us as South Africans, or for the African continent, let's say that, for the African continent, I think they should have most probably used a phased-in approach in how they say things should be done, to give people a chance to say, listen, yeah, okay, I'm not going to get admitted here, so that I can actually make plans to go to another country where I will be allowed to. And to just say straight up, and I mean specifically for the guys who's in final year, you had your site applying for articles, you get maybe most probably articles accepted. Then maybe if that was the case, if you knew before, or say, listen, yeah, let's defer this decision for maybe a 2-year period, it would give you a sufficient chance in the 2 years to actually say, I'm not going to do articles here, I'd rather apply maybe to a different country and then go do the articles there, so that I get to know how that system works and get myself equipped to actually practice law in that specific country. So for that, but obviously, it was a constitutional court judgment. The judgment came out because it was appealed from High Court and then it went NCA in that route. So it's an appeal. So you are stuck with the record. So that is what makes it a prickly pear, because you are stuck with the record. Whatever was presented in the High Court, you cannot introduce new things now into that thing. So when it comes to constitutional matters, it's now like sort of half the highest court in the country has made the decision. Unless you can maybe try, you can try and actually go for a rescission of judgment. But it's very difficult to go for rescission of judgment in the Constitutional Court now already, because this thing has happened. Most probably, if the High Court gave judgment, maybe you should have asked there for a rescission of judgment already to say, listen, yeah, maybe another court will come to a different conclusion. But now it has already gone up so high to the Constitutional Court that they very seldom will interfere with their own judgment. They very seldom, and I mean, you could see now in the public protector's case, former President Zuma's case, they all asked for rescission of judgment. The Concord just said no, and there's nowhere else to go. People always tend to talk about the African court, but that court doesn't have a bite in South Africa. And I don't think the courts will veer and people will listen to what the African court says. They don't take it seriously. So for the foreign nationals, I think it was too fast, too quick on them. And I think maybe if they used a different approach on how they say, okay, the guys who's graduating maybe this year, you will still be allowed to get in. And only guys that maybe starts the LLBs now, then you know it's 4 years from now, they are going to, and then they also have a choice to say, listen, yeah, I might not then study in South Africa. I might go somewhere else where I will be allowed to practice eventually. Of course, but to just give a final year now, listen, yeah, whoop, this is what's happening, then it's sort of half put them on a back burner. Because you know now the South African system, you know everything, how it works. And for you now to go and say, I'm going to go to Europe or America, it's not that easy. So that makes it difficult. And I think in that aspect, how they phased it in, I think there could have been a different approach. I understand where the Legal Practice Act comes from, because they say you need a special skill. But obviously, we know two lawyers don't think the same. So I can say that I can make out a case to say my way of thinking is a special skill, but they of the view that it's not a special skill to bring in foreign nationals if you have South Africans in South Africa that can perform that very same function. So that is where the problem lies. And then obviously now, if you want to ask now, most probably like for a type of visa to actually run a business here, then you need to bring something like close to, I think it's 5 million rand as investment into the country to say, I'm going to start my own law firm here. So that is the other option that you might have. But I know coming out of law school, 5 million, not in this generation. So that is the problems that I have. But I think the judgment itself, maybe they should have maybe just changed how they approach the application and implementation thereof. Maybe people would not feel so aggrieved by it, so that you get time to prepare and say, listen, yeah, then South Africa is no longer a haven for me where I can actually study law and practice law, because of the LPA, it restricts me, because certain people say, I like South Africa, I like the South African law, and I'm going to study there and practice there because I like what I see, because you read the brochures and you make up your mind. And some kids, unfortunately, they are here from maybe entering into high school. So this is all they know. So for me, I think there is most probably, or one should now obviously then put pressure on the department to maybe force the department to actually expedite the PR application process, so that you then meet that requirement to say, I'm now a permanent resident of this country. And I think what they would most probably ask you is to renounce your citizenship from the other country. Then you say, I'm going to reside now here. I'm going to be South African from now on going forward. Then also, and I mean, a lot of people is naturalized, and I mean from all over Africa. So then it would be then most probably to now go to the Department of Home Affairs, and if you have made an application and they drag their feet, you can get an interdict that actually forces them to make a decision. Be it that they grant you or not grant you, they need to make a decision, and then you can take this decision on review to say that I will grant you permanent residency or I will not. Then you can say, what's your reasons? Because in terms of Paja, you can ask for that reasons. And once you have the reasons, say, but this is not good enough, then then you'll meet that requirement of the LPA. So that is the other option that a student who's of foreign descent can also follow to actually get the PR, so that they can actually work and then become eventually resident in South Africa.
All right, thank you very much.
It's a pleasure. And now we are joined by Mr. Maboko on the hot seat. He wants to play Lobola, and he has first a couple of questions that he wants to know. If he enters into a different type of marriage regime, what is the implications? Welcome, Mr. Maboko.
Thank you, Mr. Hart, and thanks for having me.
You can shoot with a question.
So my question deals with a civil marriage, because a civil marriage is a union. In accordance of the act, it is a union between a man and a woman.
Mm-hmm.
So what if a transgender person wants to get married under a under a civil marriage? Is that permissible? For example, let's say I now identify as a male, then tomorrow I transgender and I identify as a female.
Yeah.
Then I want a male to marry me. Can I marry under the civil marriage?
Now, currently, and I think, I don't know if you check the news now lately, they've allowed like same-sex marriages, and even people that has maybe have had sex change. They allow people to do so. It's now about how you identify, and obviously we must remember the Marriage Act when it was written and how it's written. It was back then when these things was unheard of, and obviously the law is moving all the time. So nowadays people are allowed to actually have same-sex marriages. So even if you're a male and you want to get married to a male, you can do so. And I mean, there was one of the people that was on one of these singing shows that got married to a male. If you know, if you watch South African uh, television, you would have known that this guy was married to another guy, and no problem. And I know so many other people that you have, like, and I mean, there's even lawyers that I know, females that's married, and then they even get children conceived, and they become the parents of both these children. So they go to a sperm bank, they get impregnated, and there's a child born, and then that child belongs to the both of them. So nowadays, in our law, I don't want to use the word fashionable, but it's allowed. It maybe we come from a thinking that these things are not allowed. It is now that you can actually have a same-sex marriage between male and male, female and female, or even people that has changed their sex. Maybe I was male and now I go for a totally complete uh, sex change. There's the nice word, sex change. Then I can get married to whoever I'm at, because I associate myself now with a specific race, not race group, gender group. So I was male, now I'm female, and I can do that. And obviously, we have different type of marital regimes, and then obviously we talk about civil unions, all those type of things. But if you go back to the old civil marriage definition to say it's between a male and a female, the court says now, although the legislation just still stands there, the court is now sort of have changed that they allow people to do so. And we should not just look at the black letter law, but we need to now also look at how the courts interpreted the word marriage and who can conclude a marriage. Because there's a lot of cases where you can find it freely on the internet that people of same sex do get married. So it's not like in the old days where it was not allowed or it was frowned upon. These days, people do that. And as just, I don't want to mention names, then you will quickly identify with the examples. But there is a lot, and there's ones that I personally know that you get female and female that get married, and they are still females, but they get married. Or I know of males that have a gender operation to change from one gender to the other, and they then marry the person that they in love with, and it's normal. And you get males that get married to males. So many of them is it's out there. So it's no longer the narrow definition of spouse. So spouse can now include two males, two females. So it's no longer where we say spouses should be a male and a female. That's the traditional view, but the courts has moved the law in the direction that we make provision for people of same sex to get married. So it's allowed, And obviously, the marital regimes, it's still the same. You can have a marriage in community of property, out of community of property, with or without the accrual. And obviously, you can also have like what they call civil unions, where people don't necessarily take up all the responsibilities of a marriage, but it's more or less that duty to support each other and those type of things. So it depends on what you choose. So obviously, where I haven't seen is like under customary law, where I see a customary marriage that I haven't seen yet, where a customary marriage has been concluded between same-sex partners. I haven't seen one personally. Maybe there has a customary marriage happen where people would go and pay lobola and go through all the rituals of doing this thing, but in civil law, and it's from all racial groupings. It's not that there's one racial grouping that's leading the other one. It's like I've seen marriages from all racial groupings on same sex marriages.
Okay, so you are just saying that for transgender people, they can get married under the Marriages Act and the Civil Union.
Now it's like they would go under the Marriages Act. The civil union, it was created so that that civil unions was actually because people felt like the Marriages Act is excluding them and it's actually infringing upon their constitutional rights. But because now the courts has interpreted spouses and marriage in a different way compared to what we know when the act was written, that has moved that position. So civil unions, it still happens, but a civil union doesn't have the same effect and rights and obligation. On, I don't want to say obligations, but certain I say rights and maybe responsibilities that you would draw out of a marriage normally. So it's a little bit lesser where compared to where people are married, they are in a stronger position when it comes to the division of estates. If there's children born out of that marriage, like parental rights and responsibilities, also spousal maintenance, those type of things. With the civil unions, it became it's like a little bit less of uh, like maybe in normal marriage it's more expanded, the rights is more expanded, and in civil unions the right is a little bit lesser, and people tend to have like sort of that support, the reciprocal support for each other to a limited extent, and when that civil union ends, that duty somewhere also dies. But once it comes to a marriage, you can also take it after the marriage that that person has that right of spousal support from the other one. So that is the small differences that exist there, but in a marriage you are in a better position than being compared into a civil. And it's allowed now for the transgender people also to get into marriages with one another. If we are two males and the one decide, okay, I'm going to change to a female, and the other one say, I'm going to change to whatever, or we have two, a male and a female, and this one say, I want to be a male, and this one say, I want to be a female. Say the male say, I want to be a female, and the female say, I want to be a male. They can do the sex change type of thing and get married to each other.
Okay.
So it's now allowed in South African law, and that's now the constitution that played a part in saying that all is equal before the law, and you need to respect dignity, privacy, all those type of things, all the fundamental rights that set out in the Bill of Rights. And that's on that backdrop that one has to look and check these things. It's a pleasure, Mr. Maboko. We are back, and I think we've got somebody else on the what cities from that country where you need passports. They say the country of Limpopo. Mr. Rendani Dagada. He's got a question, and I think he thinks it's a question that needs to be settled. Mr. Dagada, thank you for coming with your question.
Yeah, thank you, sir. So my question relates to, before prior 2021, before the LPC actually told law firms to stop having the requirement of having your own vehicle and a driver's license as a requirement for attaining candidate attorneys positions, right? So even though the LPC has said it's illegal, it's wrong, they shouldn't do it, you'll see if you're searching for articles on websites, you'll still find some law firms, especially the medium and small law firms, they will still list an own vehicle and a driver's license as a requirement for a potential candidate before they can hire them. So obviously, I want to know, like, as a person that already cannot afford a car, definitely want to afford civil litigations against a law firm. What can I do in that situation?
Obviously, if you find out that that the law firms are still making use of this practice to say, listen, yeah, you need to have a driver's license. Obviously, if you see the advert on their websites or wherever you see it, and you can verify it comes from that law firm, you need to report it to the LPC. But you must just remember then, your application is going straight to the dustbin at that law firm. Because if they find out that it's you that reported them, obviously, I know the LPC makes provision for anonymous complaints and stuff like that. So you can anonymously complain to the LPC to say that this firm that I intend to apply for articles at that specific firm has a requirement that they need a person to have a driver's license and his or her own vehicle. But if one looks at it from a practical perspective, I would say that it's important that you do acquire your driver's license. Because what if the firm say, okay, you cannot afford your own vehicle. We'll give you a vehicle, but you need to have a license to operate that vehicle, because that's what the law expects. Because I'm giving you all the tools to perform your duty. So we can maybe get away with saying I don't have my own vehicle, but I don't think we will be able to get away with say I cannot have a driver's license. So I need to now work at getting my driver's license, so that when I get there, I say to them, yes, I can drive, here's my license, but I don't have the finances. Because that is actually where it came in, where people say that you expect a person to have a vehicle while they don't have enough money to even pay for their studies. So one can say that, but to say that writing your learner's license is maybe 140 rand now, I think, to write your learner's license. And maybe if you're lucky, you can maybe get away with actually getting your driver's license maybe with 10 lessons, maybe paying 2,500 rand, but that's already a lot for a student. So one needs to check and say, can I afford that? But that should not be the law firm's problem, because then obviously everybody will say, but I can't afford, you have to pay for me to in order to get my license. So that would be an unfair requirement on the employer, because I'm already going to take you on as an article clerk where I have to pay you a salary, knowing that your knowledge on the law is limited. So I have to train you, for which I don't get anything. I don't get a subsidy from government, nothing whatsoever. So I would rather just say, okay, I can take off my advert to say a driver's license is a requirement and a car is not a requirement. They can take it off. But who says they're not going to subtly still in their mind apply that? You cannot regulate that. You cannot govern that, because they might just have a little side caucus by the directors and say, okay, right, we're looking for a person with driver's license in his own car. But we're not just going to ask that question in the interview. Do you have your own car? Do you have a driver's license? I'm not going. So obviously they would look at your papers to see, okay, you don't have a driver's license. So if you don't have a driver's license, 10 to 1, you don't have a car. Or if you have a car, you won't be able to drive it because it will be unlawful. I cannot employ you. So that's the catch-22. The LPA tried to regulate it with legislation and sending out a directive that should not be a consideration to see if you qualify for articles or not. But there is still loopholes in that system that people can exploit. And obviously they do publish wherever they publish their adverts, or they spread it by word of mouth. And if I say on a white paper like this, I would put on an advert here, who can verify it's mine, it's coming from my firm? Because I can say anybody can just easily take my letterhead and put something on there and say that it's me to sabotage me. Then they can get out of it. So that is the predicament that one sits with. So one needs to be very careful. But I can say safely, if I send out a message, or if I say to youngsters that's going to start looking for articles, at least make sure that you do have a driver's license. That we can still complain to the LPC, say that I've gone to 10 interviews, all of them they're asking me, do I have my own vehicle? So my only conclusion that I can draw is that that is what actually threw me out of the bus, and I want these firms to be sort of have either investigated or fined, depending on the type of evidence we have against them, to say that this is out and out what they're looking for. And you can even sort of try and get further information to say, who did they employ? Okay, they employed somebody who has a driver's license and his own car. So then it means that they actually use that as criteria to determine if I get articles or not. But it's a very difficult thing to govern and control.
Okay, well, there's another thing that you said when at the beginning of your answer, right? When you were talking about how after you complain to the LPC, most likely they'll just throw, if they know who you are, they'll just throw away your application. So would you advise for somebody to complain to the LPC, or would like just
No,
get blackballed from the profession as a whole and
no,
just
I
never
would
get a
rather
chance?
say I'd rather be an ethical and upright person than actually, because it's because we do not report things to the LPC that things get out of hand. And then when it's so out of hand, now it's too big a problem to contain. But if we start complaining from the very get go, the LPC will make most probably more efforts in actually saying, they might even come up to say that if law firms has a vacancy, it must be sent to the LPA. The advert must be sent to the LPA before being placed. One can make then that suggestion to the LPA to say, listen, yeah, all law firms, when they employ somebody for articles, that advert must be sent to the ethics clearance or the professional conduct committee to look at the article, to look at the advert and see what is the requirements, and eventually if they shortlist people, they can send that shortlist again. And once if they eventually decide on who the person is, to see what criteria they looked at. That's the only way that we can fix the system, because the LPA makes provision for the LPC put these things in place, but it's still a matter of policing the actual implementation of what the LPA and the LPC is trying to achieve. So that's the difficulty of it. It cannot be policed overnight, and it will still take time for firms to get out of that notion to say, own vehicle. And obviously, you must remember these smaller firms, they're also trying to save costs. So they won't give you easily a vehicle, but they know they can benefit out of your vehicle, because what they would pay you on per kilometer, the AA rates, is way less than what you would most probably use on your vehicle on wear and tear as well as the petrol. So that for them is now sort of half survival of the fittest type of technique, to say that the bigger law firms, they might have the budget to buy vehicles or may have messengers. The smaller firms don't have that, and that's the problem that you might be faced with.
Okay. Another question. This is a tangent. I want to hear what you think about. You see, like in this venue right now, you can see a disproportionate amount of women when compared to the males. But then, if you look at the big law firms, like the big law firms, and you look at the directors, their partners, and their associates, you'll see that the proportion that you see in universities where women, there are more women in schools, in law schools, and the proportion that you see, like the top lawyers, is like disproportionately male instead of being female. What do you think about all that
No,
says?
I believe that the law profession needs still a lot of transformation, and specifically gender transformation, because the law profession is still male dominated. And you can go and look at, even in the courts of law, even in the prosecutorial side, or people holding senior position, it's more males than females. Although we know that in South Africa there's more female lawyers than male lawyers that has graduated and actually being admitted as lawyers, but it's still a male dominated sport, because our profession started back in the age old day when marital power still existed. Women were not supposed to take up certain positions, women were not allowed at certain tables. And it's like, some law firms still have the old boys club where certain things is done on a golf course, and we know not a lot of women play golf. So then certain things happen, and I say that there is transformation needed. And I mean, even we are like approximately 30 years into democracy. I mean, we had a chance now at the Constitutional Court to say, like, listen, yeah, let's put a female there to start showing South Africa that we are serious about transforming the judiciary, the legal system, and those type of things. And we opted still to place a man before a female there, which I feel should have been done the other way around, to say that female can be there for the next 10 years, which would be financial sense, and also showing that we are serious about actually bringing females into the field. But obviously, it happened like it happened, and I can just hope in 2 years' time, when there's new interviews, our current DCJ would be appointed as the CJ of this country, and maybe when she's in that position, she can also like sort of half bring women through the ranks to sit on the bench, to sit in magistrates posts, more women than we currently have. And I mean, I think we should sort of up the game because I think the ratio is maybe something like 70-30 when we get to admitted attorneys, males versus females.
But then, should gender consideration trump competency?
I'm not saying gender consideration should trump competency. You should employ a person that is competent, but then we can also flip the card around and do we say that males is more competent than females because that's what the profession is currently reflecting.
Doesn't
So,
mean
so you understand where my problem lies. So we cannot say that we think that because if we look at how many males is employed, then it would look like the males is better candidates than females. Is that really true? I cannot stand for that. So if we talk about merits then only, then we should talk about merits and then it should have been addressed long time ago. But we know where we come from. It was not only merits, but it was also gender that played a role in how our profession looks as it looks. So, in order for us to balance the scales, we need to sort of give also now more preference to females to actually level the scales. Because obviously, you cannot say, then we would say, like, okay, if we take maybe a political stance and say, okay, there's less people of European descent in South Africa compared to people of African descent, they should still be the governing party. Then you will say the majority rule doesn't apply because there's more females than males. That's for me. But you also get females would get the entry level jobs and males would get like the senior management jobs. And that is where your real problem is. Like we have a bottleneck here of females that don't break through into that top tier. And that is actually where the transformation should happen more than at the bottom because women cannot be seen as secondary income earners compared to males. That's my view. That's the whole view I hold. So I take it from there.
Yeah, that's everything I've got. Thank you.
It's a pleasure.